Cross-border hire. The law does not need changing. It just needs enforcing. The Local Government Miscellaneous Provisions Act 1976 was designed to ensure the safety of passengers. That purpose has not changed. Nor has this law been superseded by either technology or transport operators' illegal activities. Protect your licenses. You are not being told the whole truth. The greatest piece of misinformation, as a private hired driver, you have heard in the last 6 years, is there is no restriction on whether journey starts or ends for a private hire vehicle. Or this, taken from TfL's website. Currently, PHVs can undertake bookings anywhere in England and Wales. Or even this phrase, "You have the right to roam." This video explains that the phrases, being bandied about by people in authority, are not exactly correct. These phrases lead you to believe that once you are licensed by one authority, you can work anywhere in the country. The whole truth, the one that will prevent you from prosecution, is completely different. This is a controlled district. The licensing authority for this district has licensed an operator, a private hire vehicle, and a private hire driver. In this first example, the operator receives a booking from a customer, and then transfers the booking to one of the private hire vehicles inside the district. The driver then carries out the booking request by collecting the customer, and taking them to their destination. All very straightforward and perfectly legal. Where a journey can start or finish. Here we have 3 regular customers of the operator. The first one is inside the district. He wants to go to his home, which is also located inside the district. The second one is inside. He wants to go to a place that's in another district. The third one is outside the district. He wants to go somewhere in another district. There is no restriction to where a journey can start or finish. The only restriction is where the operator and the vehicle are when the transfer of the booking happens. And this is inside the controlled district. All perfectly legal. Miscellaneous Provisions Act 1976 Section 75, 1a. Nothing in this part of this Act shall a. apply to a vehicle used for bringing passengers or goods, within a controlled district, in pursuance of a contract, for the hire of the vehicle made outside the district, if the vehicle is not made available for hire within the district. When the private hire vehicle is empty, outside the licensed district, it must return empty to its licensed district to legally receive another booking. This is equivalent to a hackney carriage taxi being only allowed to switch the roof light on when inside the licensed area. Don't forget, a hackney carriage licensed taxi has an operator's license, unlike a private hire vehicle that doesn't, and must choose an operator to receive a booking. So now we understand how to legally operate. We will now explain the illegalities, and clear up all the confusion regarding cross-border hire. In this example we include 2 controlled districts. A customer is located in District B, and makes a booking with the operator in District A. The operator has 2 cars available, one in District A, the other in District B. Although the car in District B is closer to the customer, the operator can only legally transfer the booking to the car in District A. This transfer would be legal. If the operator transferred the booking to the car in District B, then this would be illegal. Miscellaneous Provisions Act 1976 Section 46, 1d. No person shall in a controlled district operate any vehicle as a private hire vehicle without having a current license under Section 55 of this Act. Subcontracting. This is probably the most important part in this video. The Deregulation Act 2015 now makes it possible for an operator to sub a booking to another operator. It has not enabled private hire vehicles the right to roam, as like many people seem to believe. Subcontracting would sometimes be necessary due to the following. A regular customer who lives in District A, is in District B, and makes a booking with his operator. Operator A does not have any vehicles available in District A to send out into District B. Therefore, since the Deregulation Act 2015, it is now legal for Operator A to sub the booking across to Operator B. Operator B can now legally transfer the booking inside the district to one of its private hire vehicles. Private hire vehicle B collects the customer and takes him home to District A. He then has to travel back to District B before legally accepting another booking from his operator. The Deregulation Act 2015 amended Section 55A of the Miscellaneous Provisions Act 1976. Now for some illegal examples. The most common illegal act that takes place today is this one. The operator is making provision outside of the area that it is licensed for, due to the private hire vehicle accepting the booking, when it is outside the controlled district. The operator is in contravention of Miscellaneous Provisions Act 1976 Section 46, 1d. If this happens, the driver would now become the proprietor of a private hire vehicle, in a controlled district, without the driver or vehicle license being in force. So the driver contravenes Section 46, 1a and b. Also, c, if the driver is an employee. Also don't forget, if the driver accepts the booking in another controlled district, the driver will then become the operator, without a license for that district, and guilty of offense 46, 1d. If the driver carries out the booking, then the driver is also guilty of offense 46, 1e. As a driver, if you make yourself available to accept and carry out the booking, whilst outside your licensed district, you will be committing almost every offense under Section 46. Another illegal example is when the operator has transferred a booking within its controlled district to a private hire vehicle, but this vehicle has been licensed for another district by another authority. Miscellaneous Provisions Act 1976 Section 46, 1e. In this example, two regular customers of Operator A are making a booking. One customer is in District A, the other in District B. The operator sends the bookings to two private hire vehicles that are both licensed by Authority B to collect one customer located in District A, the other in District B. Both of these bookings are illegal. Miscellaneous Provisions Act 1976 Section 46, 1e. The added provision to all of these cross-border restrictions is Section 75, 2. This section allows local authorities to have agreements with each other to allow licensed PH vehicles to make themselves available to their operators within those districts, without the fear of contravening Section 46, 1a, b, and c. There is lots of talk that private hire vehicles can work anywhere in England and Wales, which is true, but only if the private hire vehicle accepts the booking transfer when it's inside the district it is licensed for. Transport for London, for example, quote on their website. Currently, PHVs can undertake bookings anywhere in England and Wales, provided 1. The vehicle, driver and operator are licensed by the same licensing authority. 2. The booking is accepted by the operator within this authority, regardless of where the driver and vehicle are physically located. This is commonly referred to as the triple licensing requirement. Notice how they stated, regardless of where the driver and vehicle are physically located? This is incorrect. Many people think the triple license rule gives private hire vehicles the right to roam. We all know that the three licenses are: 1. The operator, Section 55, 2. The private hire vehicle, Section 48, and 3. The private hired driver, Section 51. There must be 3 licenses in force to become the triple license. If the vehicle and driver are not in the licensed district, but in another licensed district, then those 2 licenses are not in force. So while vehicle and driver were in another controlled district, then the following applies. Miscellaneous Provisions Act 1976 Section 46, 1, A, B, and C. A. No person being the proprietor of any vehicle, not being a hackney carriage, in respect of which a vehicle license is in force, shall use or permit the same to be used in a controlled district, as a private hire vehicle, without having for such a vehicle a current license under Section 48 of this Act. B. No person shall, in a controlled district, act as a driver of any private hire vehicle, without having a current license, under Section 51 of this Act. C. No person being the proprietor of a private hire vehicle, licensed under this part of this Act, shall employ as the driver thereof for the purpose of any hiring, any person who does not have a current license, under the said Section 51. By studying all these different sections of the Act, you will gradually begin to see what is legal, and what is not. There are no loopholes in the law, allowing private hire cars to roam. Read our documents, that go further into detail, referencing all the relevant case law, that supports everything mentioned in this video. The law doesn't need changing. It needs enforcing.